Tharp. I'm here live to take your U.S. immigration related questions. Also, to share the great news with you. We got new work permits, 4-year work permits, T visa work permits today, and one 10-year green card in the mail today. So we're very happy. The results keep coming in, and that's what we're about because the work permits, the green cards, it means that our clients' lives are changed for the positive, that they're achieving the goals that they are here in the United States to achieve, whether it's career, whether it's school, whether it is to be with family, whether it's to start a business, whether it's to just live in security and stability here in the United States. That's what this means. So we're very, very happy about the results that we're getting. And I am here to share this information so that you can also know that it can be possible for you, but you have to take action. I really would love to help you, but I can only help you where you take the action to be able to allow us to evaluate whether you qualify and get started. So the way you can do that is by getting in touch with us. Get in touch with us by calling our numbers all over my videos. And it's also going across the screen on YouTube, Facebook, and Twitch. So go ahead and just look at the number, give us a call. We have staff that answers the phone 24/7 in order to get you on my schedule because my schedule is filling up. So make sure you're taking action towards your future. And that's the first step. I'm also here to answer questions. So I know we got the question about whether there were any updates on the pause for the pause on those 39 countries, the green cards, work permit pause. We got that question. So there was a court decision in New York, a federal court decision in New York by federal judge George Russell. And he had ordered that the USCIS process the green card applications that were paused from the 39 banned countries for 83 individuals, plaintiffs who submitted a lawsuit. So this does not extend to all applicants at the USCIS, but for those who filed suit in that particular lawsuit, there were 83 plaintiffs who now the USCIS has been ordered to process their green cards. Now, what this does not mean that everybody's green cards or everybody's work permits from the 39 banned countries will be processed. It is specific to these 83 countries, but what it means is that judges are looking at this and they are finding the pause, or at least we can see more court cases like this where the judges will find that this pause is unlawful. That's what the judge found here. The judge found that there was no reason to do a blanket pause on all applications. In this case, the USCIS is authorized by Congress to either deny or approve these applications, but not pause them indefinitely. So that was a finding of the judge here. And I want to show you here that this is an example of where action leads to relief and leads to the right result because these 83 plaintiffs filed suit. And in this case, they've won. We don't know if they're going to, I can bet the federal government is going to appeal. We'll have to watch that. But it does set a precedent for other cases to come forth now and for more judges to find that the pause is unlawful so people can then see their applications being processed. So take action, guys. Don't stay stuck and frozen in fear. Empower yourselves to take action and get the relief that you deserve. All right. So we got these 4-year work permits, and right now we have VAWA adjustment of status. Those are 18-month work permits. I know people are like, what are the 4-year work permits about? And the 4-year work permits come from the bona fides that we get for our clients who apply for the T visa. So once our clients qualify for the T visa, we go ahead and we prepare their application. We prepare it for a bona fide determination, meaning they consider them for a work permit while they wait. And then they get a 4-year work permit as a result of that with deferred action. And once they get approved, they get another 4-year work permit. And after 3 years, they can apply for permanent residence. So that's what's happening. We are getting those 4-year work. We're getting more 4-year work permits now than any other type of work permit, which makes me happy. Makes me happy for my clients because they can know that they're covered until they get a final decision. They don't have to keep renewing every 18 months like the other types of applications. So if you are in a situation where you are being mistreated by an employer or any individual that you're living with and they're forcing you to do something that you are not willing to do, but you find that you have to do it because maybe you're living with them, maybe you feel like you have to do it because that's the only way to survive, or that's the only way to stay in the United States, that's where you need to give us a call and talk to us about what you're going through. That is the key here. That's how we have been able to find this relief for our clients. Is we ask questions that not a lot of attorneys ask to get to relief that can give our clients the ability to stay here and establish themselves here and get their family here as well. So we're happy about that. All right, now I'm taking questions. So put the questions in the comments so I can answer. So I'm in an abusive marriage. If you're in an abusive marriage and you're here in the US as an immigrant, you want to figure out your options, give us a call for sure. That's going to be a good starting point. Okay, what about the visa pause? So far, nothing on the immigrant visa pause, which is it applies to 75 countries outside of the US. Is it safe traveling domestically as someone who was granted asylum? That part of the travel ban. That's part of the travel ban. If you're granted asylum, then you should be able to travel, but just be aware of your individual risk. Is there anything in your background that you're especially worried about? And make sure you're talking to an attorney. Thanks for sharing the live, Lydia. Thanks for sharing the live, Sylvia. Hi, Mom Z. Nice to see you. Hi, Black Empress. I'm going to Mexico with permanent residence and passport. So, I guess permanent resident card and passport. Do they ask for anything else? So usually your passport and your permanent resident card are the basic requirements. But keep in mind, I'm not your attorney. I can't give you personalized legal advice on this live. This is general information. If there's something you're worried about, you need to make sure you're talking to an attorney. BIA denied motion to reopen for LPR through U visa, but USCIS N400 is still pending. So this definitely presents a complex fact pattern. You need to talk to us in an appointment. How long is it taking to adjust the status of resident father to a minor child? So if you go to USCIS, you'll see the processing times for the I-485 form. Look for that. You'll see the maximum processing time it's taking right now. Is Nigeria part of the 83 countries plaintiffs? So it's not 83 countries, it's 83 plaintiffs. And I'm not sure. I didn't check the nationality of each of the plaintiffs. The consulate is reviewing an arrest I had when I was 15 years old. Have you seen how long this can take? So it can vary. It can even vary based on the consulate. So I've seen something like this take a week, and then again it can take months. It even depends on what was provided. Sometimes you may provide information, but they may need more. So it also depends on a number of factors. But I would say it could be a week or it could be months. Hi, I'm going to Mexico with, okay, so I answered that. Hi there. Is it safe to travel on advance parole? I'd say be very conservative. If you're going to travel outside of the United States, advance parole is going to be what you're going to use. But you have to make sure you are looking at your individual risk. And thanks so much for the love. I appreciate it. All right. Okay, let's see. Any more questions? I'm looking for questions. Hi there, user 8116. I'm just doing the first four numbers. Hi, Maggie. Nice to see you. It's 10 now, and in March, I did biometrics for T visa. How longer I'm going to wait? Go to uscis.gov, look at case processing times, and you'll see the length of time, the maximum length of time that it's taking to process these cases. Can I travel with an extension letter? So what you're talking about is you have the 2-year green card, you're going to the 10-year green card, and you've just applied to remove the conditions on your 2-year green card to get to the 10-year green card. And you usually, once you apply to do that, you get an extension letter for 48 months that says that you continue to be a permanent resident. And the answer is yes, you must travel with that original extension letter. That extension letter is going to then allow you to um, it's going to allow you to show that you are a permanent resident in order to re-enter the United States. When do you think they're going to lift the immigration pause? So we don't have a particular timeline. Is the pause lifted for Jamaica? No, unfortunately, no. We haven't heard anything like that yet. All right, I'm on Instagram now, and then I'm going to come to Facebook and YouTube. So hang tight over there. Hi there, Ibrahim. Any news for the 39 banned countries? So not across the board for the 39 banned countries. We did have a federal judge in New York find that the pause on application green card applications in the United States is unlawful, but that's just for applied only to the 83 plaintiffs. But I'm sure we're going to start seeing more court cases coming in with plaintiffs challenging the ban. Any update on hi there, Angel. Nice to see you. Yeah, so because of the pause, I just read a question here. Because of the pause, they are doing interviews, but then they're not making any final decisions until the pause is lifted. What about asylum cases? So the pause continues for those 39 countries in related to asylum. Are they still arresting people at their interview? So, yes, it's still a possibility. Now, keep in mind that even previously, even though it is happening, it was happening. It it's really dependent on the individual, and so that but that can still happen. For example, if the individual has a removal order they don't know about, they can call ICE and have ICE detain. Also, if they suspect fraud, we have seen where they have called ICE in to take them in if they suspect fraud. They're coming into the interview and the officer suspects fraud. Will USCIS process everyone's green card from 39 banned countries, or it's only for those who sued? It's only right now, it's only those who sued. So no broader action has been brought. So um, but we are going to start seeing probably an influx of those challenges in court. And what we might see is a class action coming in. So the judge might designate a class action across the nation, and that would then enable the judge to put in a blanket order that is nationwide. Are they still detaining people at the interview? Marriage based? Yes. If you have a past removal order, criminal record, a warrant out for your immigration arrest or criminal arrest, or if they suspect fraud, then that is still a possibility. Keep in mind that it wasn't in certain areas like San Diego, I believe it was something that was happening uh, fairly often. It was prevalent. However, across the nation, in different, most other jurisdictions, it was not something that was a typical practice. So that continues to be the case. But if you have extra risk factors involved, be very careful. Wow, 4.8 K likes. Thanks so much for the love. And this means that people will see the live and be able to get information that empowers them. So I appreciate that. Please, can I file for my daughter of 32 years of age with the green card? So it's unlikely that if your daughter is here, you can apply petition for your daughter. There are certain categories in this case. If you are a U.S. citizen, your daughter's unmarried, then you could file for them in F2B category. However, if your daughter's married, you must be a U.S. citizen. So you can petition for your unmarried daughter if you're a permanent resident or a citizen. If your daughter is married, then you must be a US citizen to petition. However, keep in mind that the processing times is very long for that, a minimum of 7 years. And if you are in the your daughter is in the United States, then it's definitely not going to be a situation where she can just stay and do adjustment of status. So you have to be very careful with that. And I know a lot of people under the conditions we're working under right now, they rush and file petitions for their relatives, thinking that's going to fix it, and it may actually complicate their case. So it's important to get legal advice before you file anything. And just know that apart from if you have a child, a son or daughter who's age 21 or older, filing a petition is not going to fix the current situation, their current situation of overstay. All right, I'm on Instagram. Put your questions in the comments on Instagram. I'm looking on Instagram right now. Then I'm going to head back to Facebook, YouTube, and then back to TikTok because I'm seeing TikTok has a ton of questions coming in. So I want to answer those. How long to get BFD after the biometrics? So the timeline varies. So it's right now I'm seeing anywhere from 8 months to even over a year to get the bona fide. If I see on SIAC profile no visa, is that the reason why I can't pay the fee and upload documents? So the NVC only opens that up when your priority date is current. So if you don't see that, it may not, your priority date may not be current yet. Can I file for my, so I answered that. Looking for more questions on Instagram. I have an asylum pending since 5 years. I used to travel between states, but now is it safe? It depends on what documentation you have to travel. Do you have your work permit, your social security, and then what's your background? Are you at an increased risk? Do you have a past removal order? Are you in immigration court? Do you have any kind of criminal offenses on your record that could then set off detention from ICE while traveling? That's going to be the answer here. If you are afraid, make sure you're talking to your attorney to get some information about your risk. I put my son and mom on my VAWA petition 4 years ago. My son will be 21 this year. What will be their outcome? So your mother doesn't qualify to be a derivative on your VAWA, only your children who are under the age of 21. Now, the thing with VAWA is once you file the VAWA, it freezes your son's age. So even if he turns 21, then the VAWA gets approved, it will still move forward with processing him for the permanent residence as well. But your mom will not be able to qualify. Good evening. 48 months on I 175. Does it go to that duration? I'm not sure. Okay, 41. It can. It can. Go look at uscis.gov. Look at the case processing times for I-751, and you'll see the maximum range of time. But 48 months, it can. We've seen less, and we've seen just under 3 years. So yes, absolutely it can, especially if now your case has some complications. So keep in mind that if you are a client, make sure you are calling us. Do not discuss your case in public. One is confidential, and you could be breaking client confidentiality, attorney-client confidentiality, compromising your own case discussing. So for your own protection, please do not disclose any information about your case on the live. Can a father with a green card apply for a visa for his 5-year-old? The mom does not hold a visa. So you can submit the application for your 5-year-old, and they're still gonna, because the law does not. So the officers at the embassy, they're solely trained to look at whether did they grant this visa, which I'm assuming is a temporary visa, will the individual be at risk to overstay? They don't care about extra facts. They don't care that your 5-year-old is your child. Actually, they care, but it may actually hurt you. Because if you're a US citizen, you're a green card holder, you're applying for your child, they're going to look at it like your child is going to end up overstaying. So it's a double-edged sword in that case. You can submit it, but they may hold that against you to say your child is at high risk for overstaying that visa once they get here. If I filed all documents required for a marriage base, everything got approved and the I-485 is still pending. We are seeing that pattern where they approve some things, but then they um, they don't approve the I-45, and that could be they're doing extra checks, background checks before they actually go ahead and um, issue an approval. If a minor is on filing, can the child still apply for a visiting visa? Yes, you can always apply for a visitor's visa, but the question is, can you overcome the immigrant intent that's reflected by filing a petition? If you can, then you would be able to get that visa while on filing. And yes, that does happen sometimes, but it depends on a lot of factors. All right, so let's see. Oh, thank you so much, concerned citizen. I appreciate that. Um, all right, we have a lot of questions on Facebook and YouTube. I love this, so let's go through it, and then I'm coming back to you, TikTok. So hang tight. I'm coming back. Um, So I got biometrics last January 2nd, 2026 for a T visa. When can I have my EAD? So I wouldn't be able to give you a specific date. As I said, there's a range of time that they're taking, and you should review that range of time for the I-765. I got my green card through asylum about 20 years ago. I had an obstruction related incident, but I was never arrested or charged. So my lawyer at the time told me to answer no on my green card application when asked for about the arrest. Now I'm applying for N400 and I'm worried. Should I go ahead and apply? So, make sure that you're talking issues like these, whenever it comes to anything about criminal charges, it's very important to talk about those in the consultation. Now, I noticed obstruction related incident, but, there was no arrest. There's no evidence of criminal conduct. There was no conviction. Um, so I wouldn't be able to say anything further on that. It's hard to. It would be hard to say yes to something if there's no charges, no arrest, no conviction. It would be hard to say yes to something like that. But I'm not your attorney, and I can't give you personalized legal advice. That's why your attorney is there to advise you on it. But it depends on how is it showing up in your background. Was it really a criminal offense? If you were detained, but then and it does ask, have you ever been detained? Not just arrested, but detained. So the questions are very broad, and you have to really carefully read them to determine whether it's going to apply. There's even a section that says, um, have you ever committed a crime that you were never arrested for? I believe the question says something along those lines. So but it's going to depend on the facts, right? I don't know what obstruction related incident means. So it's whenever it comes to criminal offenses, make sure you get legal advice first on how to disclose it. The judge dismissed with no arrest or charges, so it sounded like it went to court. If it went to court, the default is going to be you need to disclose it, right? So, and these, yes, you're right. These are the things that you should be worried about at the N400 stage for sure, because if something went through the court, it means that it is on record. And if you stated no to, some, have you ever been arrested, detained, charged, and you said, because a judge can only dismiss a case where you are charged with something. So sounds like definitely need to have a deeper conversation there. Is it normal that it's been 35 days since they charged me for my marriage based AOS? I'm at USC. So is it normal that it's been 35 days since they charged me for my marriage based AOS? I'm a USC at birth. So yeah, this case type can go on for months. So I don't know what you mean by charge. If it's like you mean financially charged, or did they charge you 35 days ago? I'm not sure. But I'm assuming you're saying, is it normal for it to go by for 35 days? And the answer is yes. It can go on for even a year and a half, even 2 years if there are complications. And now, if they charged you and they didn't send the receipt notice, something is up. So they charge you for it, then you need to definitely request a second tier officer to look further into what happened. If they charged you fees for the adjustment of status and you still haven't gotten a receipt notice and they're telling you it's not in the system. Um, should I go ahead and apply? Definitely talk to your attorney. Sounds like you're already represented by attorney, or give us a call and we can talk it through to see, because I don't have all the details. I need to get those details from you. Give us a call. Now is the time to take action because my schedule is filling up. So just give us a call and we'll talk. 8.8 likes on TikTok. Thank you for that. What is the reason I-765C09 taken time approval longer under VAWA? How many months need to wait? Look at the USCIS.gov. Look at the general wait time for I-765. But yes, it is backed up. Okay, got it now. So if they charged your account, you have proof that they charged your account. No, then you need to talk to them about, you need to talk to a second tier officer. Let them know they charge you, but you don't have the receipt notice. If it's not in the system, somebody needs to look into it. So in this case, we would only do troubleshooting for a case type like that if we filed it. But we wouldn't take your case just to try to find it. Um, that we do that for our clients, but we're very busy with very complex situations, so we wouldn't be able to hunt down your receipt notice. All right. So let me see. Instagram, anything going on Instagram? Any questions? So is the 39 country green card pause lifted? No. So the case that I described, it's just the judge just ordered the USCIS to process their green card applications for 83 plaintiffs. But it does mean that we may see more court cases like this. And if they extend it nationwide, in a class action suit, we might see it go across nationwide. So let's see. If a minor is on filing, can the child still apply for a visiting visa? So I believe I answered that. It may be possible, may face an uphill battle, especially now because there's immigrant intent, but it depends on how long is the case going to the green card application going for. If it's expected to go for decades, I have seen visitor visas being approved for those, but it just depends. So So that means I will have to file different petitions for my parents. They're outside of the US. So you would know if you're applying for VAWA, VAWA does not allow you to include parents on your petition. And I really, really suggest that you get legal counsel, because, or I'm assuming you don't have legal counsel because an attorney would definitely tell you that parents can't go on that application. At the point where you can petition for your parents is when you become a US citizen. So only US citizens can petition for parents. All right, I'm on TikTok. Put those questions in the comments. So that is very complicated and fact-based to challenge, to basically challenge a removal as a wrongful removal, while even having a BIA appeal. So definitely, you'd have to talk to us to work through that and determine what's best moving forward. My priority date is current, but my I-130 is not approved. So the priority date being current doesn't mean your I-130 is just going to be approved. But if you're here in the US, your priority date is current, you have maintained legal status, and you're the spouse of a permanent resident, then you can move forward, or you're the son or daughter of a permanent resident, you can still move forward with the adjustment of status, even with a pending I-130. But it depends on your age, depends on your category. Are you an F2A? Most of those are current. If you're F2B, it's not current. So it depends. Hi, Sim. Nice to see you. Hi, Tamara. Nice to see you. Hi, Cher. Hi, Denise. Thanks for watching. Thanks for joining. Thanks for the love. We're at 10.4 K likes. Looking for questions. If someone cannot read and they want to go to do naturalization, what can they do? So if your inability to read is related to a disability or a health issue, then you can apply for a waiver of the test. It requires the physician, of course, to attest to the fact that you do have a condition that prevents you from reading, learning to read, or to do the writing test as well, if that's the case. I have worked with clients and we've gotten that done for clients, but it's heavily dependent on what's your situation, and do you have a disability or a medical condition that's preventing you from reading. So that is it. If so, you have a diagnosis, then definitely talk to us and we can help you navigate this. I filed for a year and 3 months now. No work permit. Is that normal? Unfortunately, it can, yes. Look at the case processing time for the I-765 and the longest time it takes. That's basically what could happen here. Now, keep in mind that they show the longest wait time to the shortest. So you could be in between, you could be in the middle, it could be longer, it could be shorter. But to be fully prepared for what the processing times look like, I think it's important for you to go straight to the source and look at the USCIS. Can I get a work permit while waiting for my immigrant visa? Not from outside of the United States. If you're here in the US, it depends. Like, for example, with the T visas, they allow, U visas, they allow. Do you think you should put off my case due to put off the case due to us using our personal accounts more than our joint? So when it comes on to filing marriage base, you do have to get you want to get your life started, and part of that is getting the green card. The problem I think a lot of people have is they start to look at other people's cases and they say, oh, that other person did that. We don't do that, but no, let's go do that. And it doesn't really fit within the way you're living with your spouse. So, for example, if you have a joint account, but you don't use that joint account, that can actually be a red flag. However, how do you live together? You must have an explanation and documentation showing how you are living together and managing your finances together. How are you sharing in bills? Are you selling each other money? Are you, Venmoing each other money? What I have done in cases like that is if my clients don't have a shared account, then I ask, okay, how do you do it? And then they'll be like, okay, well, we sell each other money, or my spouse is in charge of paying the light bill, so I'll sell her the money for the light bill, and then she'll sell me money for half of the health insurance, or so then we say, okay, that's where we need to show that they are commingling and working together to pay bills, is by showing money transactions between them. So that's how it has to be done. You can not everybody has a joint bank account. Some spouses don't even believe in commingling finances. So then you show how are they doing it how are they building a life together. Immigration wants to know how you're building a life together. They don't want to necessarily see that you're doing it exactly like everybody else, but they do want to see how you're building your life together. How are you dealing with money together, responsibilities together, living together? That's how you're going to show it, but you're going to show it the way you're actually living. I-130 has been approved, but however, the person who did the filing did the wrong form, as if she was here in the US, but she's not. She's in Jamaica and she's 13 years old. We have to file the I-824. That is such a pain. Yeah, because it can delay the process. Okay, I'm on TikTok, and US family member is dying. Can I file for humanitarian parole to bring her sister? So there are emergency visas that you can apply for to be able to come. The work permits and BFD you received, how long did they take? So I don't want to talk about specific timelines, just because I don't want everybody to think it's going to apply to them. So when I say specific timelines, it usually everybody then starts to say that should be me, it should apply to me, or why isn't it the case with me? What I would say is it's taking anywhere from 8 months to over a year. So, but look at the processing times for I-765, and you'll get an idea of how long those are taking. Is it fine for no fingerprint on a 17-year-old green card? So I've never gotten that question before. I'm sure it's fine. They canceled my husband's interview and haven't gave an update since December. What could be the issue? Give them a call, see if they can reschedule it, or they can push it forward. Um, it's just maybe they're catching up on interviews. Do you think I should delay my case because the bank statements aren't strong? I would not say that right now, but what evidence do you have that strong to show that you're building a life together as a married couple? How long I-705 waiver takes to be approved for F2A case? So I'm not sure what is it the I-601 waiver? So the waivers, usually if it's an inadmissibility waiver, you could be seeing a year and a half to 2 years. But always go to uscis.gov, go look at the form, the specific form you're referring to, and you'll see the varying timelines it's taking. Is it a good time to file for my wife currently? There is no better time. If you want to make sure that your wife is protected, you need to apply for your wife now. Absolutely. Delay is only going to hurt your spouse. So get on it. You can give us a call and talk to us about what your situation is. Now, keep in mind, if the delay is because your spouse came across the border without permission, it's going to be treated differently. But we want to hear from you. We're a safe space. We can talk to you about what your hesitations are, what is it you're worried about, and then we can come up with an action plan. The work permit you received, how long did it take? So answer that. How can I stop getting placed into secondary screening at the airport? So it is a pain, and under this administration, they've ramped those up. There sometimes you can submit a complaint form, and to just describe what you're going through and why you shouldn't be going through it. Sometimes that clears it out. Um, if a person cannot read and they want to do so, I answered that. How long roughly does AOS marriage based green cards take? Go to uscis.gov, go to I-485 under processing times, and you'll see it there. Is it safe to travel outside of the US with a pending EB2 I-140 petition while on F1 visa? So I guess it would be, this is very fact dependent. It's going to depend on what risk factors do you as an individual have? Which country are you from? Are you close to an F1 student visa expiration date? So it's all going to depend. This is where it's important. You're in doubt, you have worries. Do not just bury those. Make sure you are getting personalized legal advice. Um, all right. What can I do if I missed my biometrics appointment? If you have an attorney, make sure you talk to the attorney. But you can have it rescheduled, but you have to request it. You have to call. How long until visa pause is lifted? I'm waiting. We don't have a specific date right now. What can I do if I miss my N400 biometrics appointment? Give them a call and have it rescheduled. What is the processing time uh, for approval for VAWA case? Go to uscis.gov, go to case processing times, and look at the I-360 processing times, and you'll see there. All right. Wow, 13.5K likes. Thanks so much, guys. I'm going to answer the last few questions and then I'm going to head out. I definitely understand. Should not be. It's dysfunctional. I have advanced parole through VAWA 3 years now. Do you think it's okay to travel? I have a clean record. I can't tell you whether or not to travel. I know the risk is high across the board, higher across the board, and maybe very high depending on what's in your background. So they're looking at a number of things, right? They're looking at um, fraud, possibility of fraud, not just criminal record, but whether there is any issues in your background that you still want to be aware of. I'm very conservative with travel. I would say stay put right now until your case is adjudicated. You don't want to, anything can happen right now. Do you think the Dignity Act will pass? I think right now, no, where right now it's going to be an uphill battle. But I do believe under the right conditions, possibly after the next election, if we get certain people in, that Dignity Act could have a chance. So, but not right now. We could see after the election what that possibility is. What humanitarian visas would be faster, in your opinion? So they have the B1, B2 visas, and then you go ahead and apply for an emergency under that. How long does it take for green card holder to file for stepchild? 12 years. Um, so I don't have a particular. Go to uscis.gov and you'll be able to um, see for I-130. It depends on what stage you're. Are you at the I-130 stage, or are they here in the US? Have you filed an I-485? Are they outside of the United States? So it's going to depend on the timeline. Go look up your forms that you have filed, and you'll be able to see what the processing time is for the forms. I have a pending asylum case for 8 years. Can I save travel? Can I save the travel for an emergency and come back? You'd have to be very careful. I don't know where you're traveling to. If you're traveling outside of the United States, the risk is very high right now. My cousin has an approved SIJS, I-360, and legal entry. Can he adjust status through marriage to a USC? So I believe once married, the SIJS becomes they would no longer be qualified for the SIJS. But if in making that decision whether to move forward with adjustment of status rather than SIJS, I think it really comes down to trust for your spouse, because now you're involving somebody else in the process that you have to depend on to follow through, to act quickly, to cooperate with the process. So if that's the case, it can be a better and faster process. But if their spouse is someone who halfway through the process, they're going to start giving problems, not cooperating, then it can actually just make the situation more complicated. All right, that's going to be it for me, everybody. Thanks so much for your time today. It's been a really good live. I'm going to be back again tomorrow. So just make sure you like, subscribe, hit the notification bell, do what you can, follow me so that you can see when I come on, and you can hop on as well and ask your questions. That's why I'm here. But also keep in mind that what's going to get you to a point where our clients are right now, some of our clients are right now with getting their 4-year work permits, is to take action. Take action. The action is what's going to dictate your next steps, the next step to a solution. We are a safe space to talk about what you're going through, to be able to come up with a solution and then an action plan. So you're very welcome, Sandy. So call us now. We are open and ready, and my schedule is filling up. So don't wait too long, because I want to help you as soon as possible. All right. Have a good evening, everybody.